long story short, if the NTA was deficient and you were ordered removed in absentia, you can't get it reopened just because the NTA was deficient. It's pretty much the old framework that existed before Pereira and Chavez and this whole thing. You got to show that you didn't receive the notice, or you shouldn't be charged with receiving the notice of the hearing where you were ordered removed in absentia. So it's the old framework. Notwithstanding, in my opinion, and the opinion of the four-justice dissent, the plain text of the reopening statute, which included Justice Gorsuch. It's not just always the progressives on these issues. And, Justice Alito, he had me a bit until he started talking about the word change, which is in 239A, I believe. I mean, that change doesn't presuppose that there was an original hearing date. I mean, I don't know how you can change something that was never set in the first place.
Yeah. I didn't read the decision. How much into the decision was it that the practical consequences of the decision, was that really it, you think, for the conservative?
Come on, that's everything and nothing. They never talk about that. Justice Alito was the only justice in dissent in Pereira. It was an 8-1 decision, or 7-1. I'm not sure if a justice had to recuse, but he was the only justice in dissent. And in Pereira, which starts this whole deficient NDA thing, the court said, let me get the quote.
Sure.
Paragraph, this is of 239A. This is what they're talking about. And subparagraph 2 is the notice of hearing. Paragraph 2, the notice of hearing statute, presumes that the government has already served an NTA that specified a time and place, because otherwise there would be no time or place to change or postpone.
Yeah.
That is a quote from Pereira. That Justice, Alito was the sole justice in dissent, and, his day has come. I guess this was too far. What's happening? Who knows in the background that convinced the other justices to kind of contort the text a bit and get to this result. Maybe they didn't want to open the floodgates. But four or five circuit courts had already held that the plain text means the opposite. The Fifth Circuit was all over the place a bit. The 11th Circuit, it was kind of weird. No court had really said that the plain text allows a notice of hearing to clean it up. But Justice Alito did. I mean, I find it very hard to believe that, 22 appeals court judges couldn't read this text? They were so wrong with this text. It is surprising. Not to mention the four-justice minority in this case. So it is too bad, but let's be real. It was always a technicality argument. Some of them.